Good afternoon. I am Martha Minow, the dean here, and it is my great pleasure to welcome you today. Indeed, it brings me enormous professional and personal pleasure to welcome you to this special occasion. Right on the dot, thank you, clock. Bestowing a chair is the highest honor that Harvard Law School can give to a faculty member. Today, Professor Jody Freeman becomes the Archibald Cox Professor of Law. That's pretty awesome. So it's a pretty special chair. I give special welcome to Jody's mother, Natalie, to the distinguished Jack Austin, former Canadian Senator, HLS alum in the L.L.M class of 57, and also Jody's stepdad. We welcome Jody's brother, Richard, and family, Kathy, Gabby, and Harry, Jody's formidable aunts, and cousins from near and far, the amazing Sharon Dolovich, friends of the Cox family, and all others here today. Everyone, just settle in, because I have things to say before we get to the main act, so just patience. This occasion actually marks the launch of a brand new chair, and that's a very special time indeed. This chair is enabled by the superb generosity of a 1948 graduate of the law school, Richard Weary, whose brothers Thomas and Daniel are also HLS alumni. Richard's success as a founder of 3 cable companies and the leader of the National Cable Television Cooperative provided leadership to this vital industry and to his home state of Kansas. He and his wife, Dale, generously created a chair in their name at Harvard College, and they also created an endowment fund that allowed us to establish a new chair here at the law school. And we thought about who exemplifies values that we would like to honor. Naming the chair for Archibald Cox honors one of the truly preeminent lawyers of the past century. The name of Archibald Cox is synonymous with public service, with integrity, with legal acumen. Law clerk to Judge Learned Hand, Assistant Secretary of State, Chief of the Wage Stabilization Board after World War II, Solicitor General of the United States appointed by President John F. Kennedy, successful defender of reapportionment in Baker versus Carr, successful defender of the Public Accommodations Law and the Voting Rights Act. Archibald Cox's base of operations at Harvard Law School, when he was a celebrated teacher of labor law and constitutional law, was the anchor for a career of exemplary public service. Perhaps Cox became most well known as special prosecutor who investigated the Watergate scandal. Upon discovering the secret tape recordings made of all conversations in the Oval Office, watch what you do right now and what you say, who knows what's going on here, Cox demanded that the president turn over those White House tapes to assist in the investigation of White House involvement in the spying and interference with the presidential campaign process. President Nixon refused to turn over the tapes. Archibald Cox remained steadfast, even when the White House made clear that he would lose his post. There's some seats up here, if anyone wants any. Attorney General Elliot Richardson and Deputy Attorney General William Ruckelshaus stood by Cox, and each of them resigned rather than take President Nixon's direction to fire him. Ultimately, he was dismissed by Robert Bork, and Cox memorably said at that time, "Whether ours shall be a government of laws and not men is now for Congress and ultimately the American people to decide." The outpouring of public support was later reinforced by a Supreme Court decision directing President Nixon to turn over those tapes. Archibald Cox returned here to teach. He also founded the public interest advocacy group Common Cause, and he successfully defended the constitutionality of the post-Watergate public financing of presidential elections in the United States Supreme Court landmark, Puckley versus Vallejo. Archibald Cox was classy, upright, dapper with bow ties, author of notable works on constitutional law and labor law. Professor Cox celebrated what he called the great American adventure in self-government and the right to participate. He described that right to participate as a great privilege and also an obligation. Strength of conviction, devotion to the public good, fine posture without posturing. Who might I be describing today? These qualities so aptly describe our honoree. Principled advocacy in the public interest well captures Jody's co-authored amicus brief on behalf of former Secretary of State Madeleine Albright in the landmark U.S. Supreme Court global warming decision in Massachusetts versus EPA. Her inventive and insightful work places her at the forefront of her two fields, environmental law and administrative law. Her award-winning work on collaborative governance instructively highlights the private role of public governance and the potential role of public norms in privatization. Her administrative law writings are translated in many languages. A collection of her articles appeared in China last year. The American Bar Association's Administrative Law and Regulatory Practice selected her article, Private Role in Public Governance, as the single best article in administrative law in the country that year. Similarly, the Environmental Law Institute selected her Climate Change and U.S. Interests article as one of the best articles of 2009. She's the co-editor of a leading environmental law casebook and of a crucial book studying market-based environmental regulation. Her co-editor, Jack Bierman, describes her contributions to the forthcoming edition of a leading administrative law text as stellar, although he also complains that with little practice, she outdrove me on the golf course last fall, although she did inspire me to play very well that day. Her capacity to inspire and to lift up the quality of others' work is renowned, and about this I give personal testimony. Jody was first my student, working on RegNeg and collaborative governance. She quickly taught me and challenged me to think harder, tougher, and more creatively. When we worked together to frame a conference and then our 2009 book, Government by Contract, Outsourcing and American Democracy, a title that, shall we say, went through many revisions, I learned some of the secrets of Jody's success. She demands excellence. She rewrites and reworks what seems good enough until it's much better. She embraces competing points of view. She challenges those who hold them to abandon caricatured views of one another. Her gifts of persuasion make our chapters in the book better. She made contributors revise and refine their work. And here is why. I know that leading environmental law scholar Richard Lazarus, who's here today, is right when he reports, and I quote, Professor Jody Freeman is without question primarily responsible for President Obama's single greatest achievement in environmental law. During a political climate in DC, when political consensus has proved elusive even on the easiest issues, Freeman tapped into her celebrated scholarship about public and private governance and brokered a deal, bringing together factions that had been bitterly warring for decades, including auto companies, governors, environmentalists, state and federal transportation officials, state and federal environmental protection officials, and achieved a truly historic agreement on fuel efficiency and greenhouse gas emission standards for new motor vehicles. No one else had the requisite skills, credibility, and stature to pull off this feat, says Richard. This, of course, was but one of her accomplishments as White House Counselor for Energy and Climate Change during 2009 and 2010. There, her work addressed the historic infrastructure and renewable energy investments of the Recovery Act, a successful House vote on the climate change bill, as well as these toughest fuel efficiency standards and greenhouse gas standards. An internet site known as the Green Blog noted her departure from Harvard to Washington as a sign of, quote, the environmental brain drain to DC. Here at Harvard Law School, Jody's distinguished public service falls in the direct line of Archibald Cox, and we honor her service and with joy have welcomed her back. I hope, Jody, you're getting a bit more sleep than you did in Washington, but frankly, I'm not sure if you are how, because Jody was recently selected to be a public member of the Council of Administrative Conference of the United States. That's the independent agency that is charged with improving the efficiency and fairness of federal agencies. Also, Jody played a leading role in helping to organize EPA at 40, the all-day conference here at Harvard Law School this past fall that joined together the law school, the Harvard Kennedy School, the Harvard School of Public Health, and the Harvard University Center of the Environment. Almost harder than what you did in Washington, actually, to get those guys together and bring to campus the Vice President Al Gore, EPA Administrator Lisa Jackson, former Administrator William Ruckelshaus, and many others for intensive discussions and analysis of where environmental law and regulation has come and where it needs to go. She has renewed her efforts as founding director of the Harvard Law School Environmental Law and Policy Program and works alongside clinical professor Wendy Jacobs in building out intensive collaborations across the university with municipalities and states, industries, and scientists. Her vigorous teaching now includes our first ever course on climate and energy law and policy, with cutting-edge treatments of electricity transmission, nuclear power, hydrofracking, and carbon capture and sequestration technology and law, and with the participation of distinguished public officials and scholars. She's testified in Congress before federal and state commissions. She served as vice chair of the ABA Administrative Law sections and also chaired the Executive Committee of Administrative Law for the American Association of Law Schools. And I've often wondered whether Jody's appreciation of the environment reflects her childhood in Vancouver, British Columbia. I understand her parents still can't believe that she left. And perhaps, though, it's the undergraduate work at Stanford or the varsity volleyball experience there. After studying law at University of Toronto, and I know some of her classmates are here, she clerked at the Ontario Court of Appeals for future Canadian Supreme Court Justice Louise Arbour. When she came to Harvard Law School for her LLM and S.J.D degrees, we knew great things were in store. She served as a law professor then for 10 years at UCLA, where she founded the Environmental Law Program and won the Rudder Award for Excellence in Teaching. We rejoiced when Jody Freeman joined the Harvard Law School faculty in 2005, and perhaps her appreciation of energy issues reflects her own energy. One colleague noted, and I quote, "Jody is an exceptionally generous, dynamic, and inspiring colleague with turbocharged intellectual firepower. I'm energized when I find myself in the same room as her." Another said, "She has a vision for solving environmental problems without resort to litigation. She's a wonderful and supportive colleague." And finally, one colleague who had a sneak preview of today's lecture said, "What makes Jody's work so important and original is her refusal to accept received frameworks for thinking about how regulatory governance works. Her scholarship is both revelatory and generative, revealing important problems that had been neglected, suggesting creative ways to reconfigure our institutions to better serve the public interest, and opening up whole new fields of research. Her chair lecture does all these things." The chair lecture is entitled Coordinating Agencies in Shared Regulatory Space. I know we're in for a fantastic lecture. No pressure, Jody. And I ask you to join me in welcoming the very first Archibald Cox Professor of Law, Jody Freeman.
Well, stacking the room certainly worked. Thank you for that. Where's Martha? Thank you, Martha, for that extremely generous and warm, lovely introduction. The best thing to do after something like that is to say thank you and sit down. And thank you all, my wonderful colleagues and my fabulous students and my fantastic assistant, Kathy Curley, and my wonderful, so many close friends and family who traveled so far to come here today. Thank you to all of you for being here. I'm doing fine, in case you're wondering. Right before we came in, my mother hung back from my family and said, "Don't worry, we love you, whatever happens." Which is how I grew up. It is especially meaningful to me that I'm receiving this chair from Martha Minow, who, as she said, was my mentor when I was a student at HLS. So we go way back. And I can honestly say that if it were not for her, I would not be here. Without her unwavering support, generosity, and intellectual guidance, this career would not be possible. But I can tell you it's always a little daunting when you are writing something with your former supervisor. I remember when her daughter Mira was born. Mira is now in college, to give you an indication of the time that has passed. And like all graduate students, I totally unselfishly thought, what about me? What will happen to me? Will she have time for me? And the remarkable thing about Martha is she did, and she always does. And people here know that about her. And so I'm very grateful for that and for today and for so much else. I want to say, too, a few words about Archie Cox, revered Harvard Law School professor, famed Solicitor General, and iconic Watergate special prosecutor, one of the true legal giants, a man known for, as Martha said, his integrity and commitment to public service. I am so deeply honored to be receiving a chair in his name. I never knew Archie. He died shortly before I joined the faculty, and I'm poorer for it. Archie is, as Martha said, best known for his role in the Watergate investigation. Phil Hyman, a wonderful colleague who spent, that's a reminder to mention my Auntie Shirley. Phil Hyman, wonderful colleague, spent some time talking about Archie with me. He spent almost 40 years at Archie's side working with him at every step of his career. And we had a great conversation, and Phil described the Watergate days to me. And he said that Archie's team of hard-nosed prosecutors revered him, even though they're a tough bunch, and Archie knew nothing of criminal law before he took this job. But he said it was a frightening thing to pursue the President of the United States, and they were scared. And Archie was a pillar of honor and respectability and public articulateness, these are Phil's words, and he gave people confidence, and his very presence told them that it would be all right. In the famous incident Martha described, known as the Saturday Night Massacre, when Attorney General Elliot Richardson and Assistant Attorney General Bill Ruckelshaus resigned rather than fire Archie, and finally, after he was fired by Robert Bork, Archie, just before he was fired, went out and gave a press conference, and it was masterful. There he was in his bow tie and his crew cut, very tall, and he said simply, without a trace of arrogance or presumptuousness, that he did not want to disrespect the President, but he'd been given a job to do, and that he had an obligation to do what an honorable person would. Earlier, Archie was one of the closest advisors to President Kennedy during the 1960 campaign, and then, as Martha mentioned, was appointed to be the Solicitor General. The story goes that when he was Solicitor General, the President Kennedy, would call up Bobby and say something to the effect of, can I, take over can I seize the steel mills or the equivalent? And Bobby would say, think for a minute, and he'd say, yes, Mr. President, I think you can. And then there would be a pause, and President Kennedy would say, ask Archie. This again from Phil Hyman's recollection. As Solicitor General, as Martha said, Archie defended key aspects of the 1964 Civil Rights Act and argued landmark civil rights cases that have become part of the fabric of constitutional law. He also wrote most of the 1965 Voting Rights Act. He was at the time, and perhaps is now still, the most successful Solicitor General in U.S. history. When he argued, I've been told Archie always had 3 points. He said you should have 3 points, even if you only had 2, because you would think of one along the way. Although he became a treasured national figure for his public service and reached the pinnacle of power at a transformative time in American history, if you asked Archie who he was, he would say, I am a law professor. He thought this was the highest calling and the most important thing he did. He was a nationally known expert in labor and constitutional law and the author of several books in these fields. He was a devoted but intimidating professor. He warned his students sternly to plan their time well for exams by telling them a story about what not to do. One year, one of his students, he said, had run out of time, ripped out the last 100 pages of his casebook, attached it to the exam, and written on it, the answer is somewhere in there. To be invested in a chair that bears this man's name, a man who strode with confidence across the landscape of every domain he entered and inspired generations of lawyers, scholars, and public servants, is humbling, daunting, and inspiring. Which leads me to my argument for today. In his State of the Union speech last month, President Obama got one of his biggest laughs when he said, quote, there are 12 different agencies that deal with exports. There are at least 5 agencies that deal with housing policy. Then there's my favorite example. The Interior Department's in charge of salmon while they're in freshwater, but the Commerce Department handles them when they're in saltwater. I hear it gets even more complicated, and here he smirked, once they're smoked. I nearly leapt off the couch at this and started maniacally texting my co-author, and all I could think was, this guy is stealing my chair talk. The president said in response to this that he plans to merge, consolidate, and reorganize government, suggesting that the problem is wasteful duplication, and if we combine all authority together, eliminate a few agencies, and slim things down, it would fix things. I hate to say this, I really hate to say this, but the president is wrong. It's true that salmon spawn in freshwater rivers and lakes and spend most of their lives in saltwater coastal areas. It's true that the Fish and Wildlife Service and the Department of the Interior manages the freshwater habitats in which they reproduce, and that NIMFS, the National Marine Fisheries Service, this is just the beginning, in the Department of Commerce regulates offshore commercial fishing of salmon, sets the catch quotas, etc. And it's true that when the fish are processed so you can eat them, and when they're canned or smoked, they're inspected and regulated by the Food and Drug Administration or the U.S. Department of Agriculture. But you cannot consolidate your way out of this problem. The agencies each play a different functional role, and if you want these roles performed, someone or some agency has to do it. The essential challenge of this fragmented regime is coordination, and that is what I want to talk about today. In the tradition of Archie Cox, I have 3 points. Of course, there are several subparts to each point. The first point is, fragmentation is a prominent, pervasive, and stubborn feature of modern governance. Yet traditional administrative law has trouble conceptualizing it, even seeing it, let alone addressing it meaningfully. Administrative law focuses on agencies pretty much all the time acting independently, not really focusing on the interplay among them. The key purpose of administrative law, that is the purpose of the courts, is to constrain agencies to ensure they don't overstep legal bounds and that they remain faithful to the tasks that Congress has assigned to them. Judicial review is therefore a project of constraint in this traditional conception of the field. If you flip through any administrative law casebook, including my own with Jack Bierman, it's almost impossible to find a case that features more than one agency, even though almost every case is part of a larger regulatory or administrative regime in which many agencies are at work. Fragmentation is most visible to us in times of emergency when failures of coordination are in part responsible for a government failure to respond to a tragedy or for a muddled government response. So failures of coordination were blamed in part for the U.S. government's failure to prevent the attacks of September 11th, 2001, blamed in part for the Bush administration's lackluster performance in the wake of Hurricane Katrina in 2005, and blamed in part for the Obama administration's uneven response to the oil spill last year. But fragmentation and dispersed power characterize almost every sphere of social and economic regulation, quite apart from in emergency situations, and it affects agencies in their everyday work. Congress often gives numerous agencies some responsibility for some aspect of a related problem, and this is true of everything from border security to food safety to financial regulation. So to give you some flavor for this, I'm going to make you listen to a few examples. But it is designed to illustrate the complexity of the institutional design. Think about the food safety regime. 15 federal agencies playing distinct and not redundant roles in implementing 30 different statutes. They're responsible for standard setting, implementation, and enforcement. The FDA governs most of this. The FDA regulates almost all food products except meat, poultry, and processed egg products, which are within the jurisdiction of the U.S. Department of Agriculture. The two agencies perform essentially the same function, but in different domains. Food security, however, is the responsibility of the Department of Homeland Security, whose functions include monitoring and surveillance programs. EPA regulates the toxicity of pesticides and maximum allowable residue levels on food commodities and animal feed, and has authority over matters that affect the food supply indirectly, such as water quality. Think about Border Patrol. Similarly divided among many agencies: Fish and Wildlife Service, Bureau of Land Management, Bureau of Indian Affairs, National Park Service, Forest Service. All of them must coordinate with two agencies, at least of the Department of Homeland Security. The Federal Counter-Narcotics Mission at the border requires the DEA, the Drug Enforcement Agency within administration, within the Department of Justice, to partner with two Department of Homeland Security agencies known as, stick with me, this is like class, Immigration and Customs Enforcement, which is responsible for addressing vulnerabilities in the nation's border, economic, and transportation and infrastructure systems, and Customs and Border Patrol, which is responsible for preventing terrorists from entering the United States. And both of these agencies have authority over drugs entering the United States, which has led to some operational inefficiencies and conflict. For example, drugs seized by The Customs and Border Patrol between ports of entry are referred to the Drug Enforcement Administration, but drugs seized at ports of entry are to be referred to the ICE. And the president thought the salmon situation was bad. Financial regulation. Numerous agencies responsible for regulating some aspect of the financial sector, including the SEC, the CFTC, the OCC, the FHA, the FDIC, and the Federal Reserve. The Dodd-Frank Wall Street Reform and Consumer Protection Act, the Wall Street Financial Reg Reform Bill that was passed last year, overhauls key aspects of U.S. financial regulation and addresses the need for coordination among these agencies, and created a new multi-agency Financial Stability Oversight Commission to address systemic risks to the financial system that none of these agencies could address alone. During deliberations over the Dodd-Frank bill, many jurisdictional questions arose, and Congress contemplated establishing a single financial regulator by merging them. But they rejected it, and Congress instead maintained the SEC, the Securities and Exchange Commission, to regulate securities, and the Commodities Futures Trading Commission to regulate futures. And historically, they fought over what happens when you have futures contracts based on securities. To assign authority over derivatives, which had previously been unregulated, as you all now know, Congress gave the SEC the security-based swaps and the CFTC all the other swaps. This pattern is reproduced in many, many other areas. I'll give you one last one. The one closest to home for me, federal resource management. Management of the public lands and resources and protection of the environment. Consider the fragmented federal regime for siting a transmission line on federal lands if you want to take electricity from where it's produced to load centers where it's consumed. To site a transmission line can require permits from up to 9 different federal agencies, and I'm not even talking about the states that get involved. The Department of Energy, the Department of the Interior, Department of Agriculture, Federal Energy Regulatory Commission, and the Department of Defense each have some land management responsibilities or other regulatory responsibilities that come into play. Each and every one of them is part of a complicated decisional process. The literature on this state of affairs in political science and in law treats this primarily as a problem of redundancy, as the president did. And in my view, understanding it simply as redundancy misses all of the institutional complexity in this design. There are quite different regimes that Congress sets up to accomplish different purposes. And you can distinguish among different kinds of delegations, and it's much more important to get a granular feel for them than to lump them all together under a term called redundant. For example, Congress can give more than one agency the same function, but they can be regulating different parties or different products. Congress can give different aspects of implementation and enforcement to different agencies. It can tell one agency to set the standards and the other to adjudicate disputes that arise under those standards on purpose, to insulate the adjudicating function from the regulating function. Congress can give one agency conflicting missions, tell it to produce power, and then tell it to protect the environment, and then give, I'm looking at J.R. DeShazo, my co-author on this article, and then give other agencies some power to essentially lobby that agency to make sure the balance is right between those potentially competing functions. And finally, Congress can assign some small piece of related authority to different agencies who need each other to work together to solve a larger problem. Those are different things, and they require different kinds of coordination mechanisms. Even if you consolidate to some extent the vast federal bureaucracy, even if you try to reduce literal duplication, of which there is no doubt some, what you are left with is an irreducible minimum of fragmentation and dispersion for which you need coordination strategies. Now, why does Congress do this is a question that comes to mind. It looks like a glorious mess, to quote one member of Congress. There are competing theories about this in political science, and legal scholars have drawn on them to think a little more about it. One is that it produces benefits for Congress. That is, they delegate to multiple agencies, and that creates a kind of interagency competition to produce information and expertise, and that helps Congress make judgments about whether the agents to which they've delegated this power are behaving the way Congress wants them to. Some theorists think it's an insurance policy against one agency's failure. Somebody else will pick up the slack. Some scholars think that the delegation to more than one agency will better approximate the preferences of all of the players negotiating the law in the first place, the House, the Senate, and the President, so that if they can't get exactly what they want, it comes closer to what they want if they actually disperse the power. Some scholars, and I'm partial to this, think this is just the product of the committee system in Congress. That is, you're sitting on an oversight committee, you have authority over certain agencies, and the last thing you want is to lose your authority to deliver benefits to your constituents because you no longer sit on an oversight committee. And also, this is partly the product, they think, of the constituent groups that build up to support the agency, so that what happens is the oversight committees and the constituent groups that support the agency get together and fight for a piece of any new regulatory authority that surfaces and say, give it to us. And the reason I believe this is I got a chance to see some of it. There was a great, it's just scary. There's a great example during the negotiation of the climate bill that ultimately was halted in the Senate but got out of the House. And at one point, the chairman of the House Ag Committee would not let the bill get out of committee until he was assured that the Ag Committee was going to have authority over share it with EPA, that USDA would share authority with EPA over what counted as agricultural offsets that would be giving credits into the system for GHG reductions. The idea that EPA would decide which agricultural reductions counted made them apoplectic, and they said, our committee sits over jurisdiction of the Ag Agency, and we want a share of the pie. The final reason why Congress might do this, and I'm also partial to this explanation, is that this is, in some significant measure, the accidental byproduct of a legislative process that occurs on a rolling basis over time with different enacting majorities of Congress that don't always look back to see what the prior enacting majorities have done, and which often produces inconsistencies, inefficiencies, and unintended consequences. If you asked me right now, I would say the last two answers I think explain most of what's going on, but the jury is still out. The beauty of this is it doesn't matter to me what the reason is, as fascinating as it is, because what matters is that all of these theories are seeking to explain something that is real and that creates an enormous coordination challenge for the agencies and a monumental management challenge for the president, whose constitutional duty is to take care to faithfully execute the laws. Now, all of these players, Congress, the agencies, the president, possess a variety of tools for dealing with this problem, which they do already use, but could use much more deliberately and effectively. And I'm just going to talk about a few of those strategies. Structural integration, interagency consultation requirements, memoranda of understanding, which are like quasi-legal agreements between the agencies, and joint rulemaking, or policymaking that binds the agencies together to enact a single regulation. Structural integration. The Department of Homeland Security is created in 2002 after the events of September 11th, 2001, the largest restructuring in United States history since the creation of the Department of Defense in 1947. Brought 40 agencies together under one roof. Structural integration is costly for Congress and politically inconvenient for any agency, any oversight committees that might lose their oversight jurisdiction. It's just politically difficult and expensive in terms of appropriations, and so perhaps for that reason it's not done very often, usually in response to major emergencies or breakdowns. I was talking about this with Matthew Stevenson, a young colleague here at the law school, and he said, well, this reminds him of the first, he actually said this, of the first sentence in Romance of the Three Kingdoms, which is usually attributed to Luo Guanshang, who wrote in the 14th century. This is Matthew, who wrote in the 14th century. He said, this reminds me of that. The first line is, the empire long divided must unite. Long united must divide. Thus it has ever been. And that is what we know how to do. That's why Lego is on my poster. We take it apart and we put it together. Richard Lazarus is here. He's the executive director of the President's Bipartisan Commission on the Deepwater Horizon oil spill. I'm sure he'd be willing to talk about their report after the talk. What people wanted to do after the oil spill was take apart the Minerals Management Service, which is what, at the President's direction, the Secretary of the Interior did. Broke off the part of the agency that issues permits for offshore drilling from the part of the agency that regulates environmental compliance and safety risk, and from the part of the agency that collects royalties, revenue from offshore drilling. But you know that this just undoes what was done in 1982, which was to combine those very three agencies together into one. I am skeptical of major reorganization efforts that seek merely to consolidate what was once separate or disaggregate what was once merged, without truly operational, functional integration of the daily policymaking task of the agencies through cross-cutting teams that can mostly be accomplished without doing anything to your organization chart. The second tool that all of the principals have, Congress, the President, and the agencies themselves, is interagency consultation. Now, there are many, many of these provisions Congress has mandated. They've required agencies, in many cases, before they can act, to consult with some of their sister agencies that may have related expertise or interest in the area or some related statutory authority. And these consultation requirements escalate from the mere obligation to consult, to the obligation to respond to the comments, to the obligation to accept the recommendations as a default unless you can come up with a reason to explain why you don't want to, and it makes sense not to veto power for the consulting agency, which forces a negotiation before the action agency can act. And Congress does this all the time in very different statutes, so it knows how to deploy that that tool. The best example might be NEPA, the National Environmental Policy Act, which is a landmark statute that required that agencies, for the first time, study and disclose the environmental impacts of what they were proposing to do. Build a dam, build a huge water project, build a highway, or fund any of these projects. You have to disclose the environmental impacts. This has served as an umbrella process for all the federal agencies to actually go through that analytic process, which necessarily means that they wind up consulting with other agencies with expertise. The trouble with NEPA, as with all the consultation requirements I described, with the exception of the veto authority, is that they are procedural. So the action agency can go through the process and consult and comment and reply and take under advisement and do the analytic work, and then ultimately do exactly what it wanted to do and make the substantive judgment it ultimately wanted to make in the first place. And that is the limitation of an ultimately procedural statute. The third tool that all of the principals have at their disposal is the informal contract-like agreement that I mentioned called the Memorandum of Understanding. This is a very flexible kind of agreement that agencies strike. There are thousands of them in the federal government. There are thousands of them between federal agencies and states. There are international MOUs. And basically, they're good for anything. If the agencies want to launch a joint project, if they want to produce information together, if they want to align procedures, MOUs are very flexible, highly adaptive, and like I say, contract-like instruments. There is a good example I can come up with, deals with the transmission problem I described at the beginning of the talk. The 9 agencies that have some authority over siting a transmission line got together in the Obama administration and hammered out a memorandum of understanding that streamlines and consolidates a multi-agency permitting process. So there's a lead agency, there's one record, there's one set of environmental reviews, and the decision-making happens in an integrated way rather than a serial way. And now you could say this is just procedural, it's just housekeeping, but it has substantive effects. If it cuts permitting times by a quarter and applicants get to site their transmission lines, that makes a difference. If it improves the decision-making, so agencies are talking earlier rather than later with each other, it improves the quality of the decision-making process. The almost last example of the tools that can be used to coordinate is joint rulemaking, which has received new prominence in the Financial Reform Act that I mentioned, the Dodd-Frank Act, where Congress has mandated joint rulemaking among the many financial regulators for an astonishing number of rules, or at least authorized it for another astonishing number of rules, suggesting that Congress is turning increasingly to joint rulemaking to try to manage fragmentation. The best example I know of, which I've told my students all about and talk about quite a lot, is actually not a joint rulemaking that was initiated in response to Congress, but was initiated in response to the President urging EPA and the National Highway Traffic Safety Administration and the Department of Transportation to get together and promulgate rules regulating, as Martha mentioned, greenhouse gases, the first greenhouse gas regulation in US history, and fuel efficiency. The reason this happened is that before the Obama administration came into power, the auto industry was facing a very fractured patchwork kind of regulatory regime with NHTSA, the Highway Administration, exercising its traditional authority to set CAFE standards, which you're all familiar with, the fuel efficiency standards, MPGs, 25, 35 MPGs. 35, no, never, 25. And suddenly, because the Supreme Court decided Massachusetts versus EPA, the EPA was acknowledged to have regulatory power under a different law, the Clean Air Act, to regulate greenhouse gas pollution coming from cars. Different mission, pollution, fuel efficiency, but essentially regulating the same thing, what comes out of the tailpipe of the cars. And in addition, there was a complicated situation in which California was also setting its own standards and 14 states were following it. If we had time, I would spend an hour on this, but I won't. The point is that the solution to this occurred because the agencies decided to bind themselves to the mast. The two federal agencies go through a joint rulemaking together, form joint teams to model the outputs, use the same inputs, argue over their legal obligations under their respective statutes, align and harmonize their compliance programs, and produce a single unified national program that California agreed to sign up for and that the entire auto industry, the labor movement, and the states signed up for as well. The use of the joint rulemaking mechanism forced the agencies to confront their potential inconsistencies early on. It forced the lawyers to confront the vulnerabilities of the rulemaking early on. And all of that has produced a joint and uniform regulation. The final example of a kind of coordination tool that can be used is the most controversial, which is the White House, exerting centralized control over agency policymaking to try to promote more coordination. Now, of course, there's no such thing as just abstractly, objectively promoting coordination. Of course, the president is going to try to implement his policy objectives through that coordination, and that is the reason why it's so controversial. The president has a number of ways to do this. The most institutionalized mechanism for doing this is through an obscure office that is headed by Cass Sunstein, our colleague, called the Office of Information and Regulatory Affairs, with this name that doesn't suggest that it has any power at all, but it in fact is hugely powerful. And it is this office that is charged under an executive order with reviewing all of the regulations that are significant that come from the federal agencies. And in that capacity, OIRA sits atop the federal agencies and determines whether they are producing sufficient cost-benefit analyses to justify their significant rules. There's another function that OIRA performs as part of that, and that is a planning function. So the agencies must disclose their plans for regulation in advance twice a year, and OIRA oversees that planning, but typically under this executive order, they simply review it and send it back without monkeying too much with the plans. The OIRA regulatory review process for major rules that have an annual impact on the economy of $100 million is an elaborate, detailed, heavily analytic cost-benefit analysis process. OIRA exerts a very powerful function disciplining the agency's use of cost-benefit analysis. It is not clear that OIRA uses its authority under the executive order to actually promote, in a proactive way, coordination, collaboration, consistency, and harmonization, but rather is more reactively responding to the analytics in the cost-benefit analysis, a narrower role than one might envision. But the executive order currently in place actually authorizes OIRA to do this through the planning process, and it actually literally mentions, it actually says, the executive order, that agency rules must be consistent with other agencies' regulations. So there's an authority there that OIRA could be exercising. If, apart from OIRA within the White House structure, of course there are just high-level White House offices with so-called czars running them that can exercise a coordinating function. And there's a variety of these, you know what they are. Different presidents have put them in place for different reasons: drug policy, AIDS policy, energy and climate policy, and Congress sometimes creates these offices. There's a very institutionalized process that was long ago established, the NSC, the National Security apparatus within the White House, that actually coordinates between the Department of Defense and state, and that's very institutionalized as a coordination mechanism. So there are ways to do this. The principals know how to use them. They have them at their disposal. And I would argue, my view is that there are tremendous benefits, as you can tell, to coordination. I think it generates valuable expertise and information. It improves the quality, of agency decision-making. It can harmonize potentially inconsistent approaches. And it can reduce both public and private transaction costs. But it comes at a potential cost. Because by definition, coordinating raises the decision costs for the agencies. It takes time, it takes effort, it takes patience, it takes resources to actually work things out with the other agencies. And so the question is always, is it worth it? And it's very hard to know in any one case whether the coordination effort is worth it, partly because we have no way of tracking it. We don't track it. We don't compare the cost of joint rules to the cost of rules promulgated independently. We don't even try to assemble a set of illustrative MOUs and track whether they actually got implemented and find out if they saved anybody any money or any time or improved the decision-making process. So the process of comparing costs and benefits is hard, but I would suggest that there are more, even the upfront cost of more coordination can be worth it if it actually anticipates more costly problems or intractable problems that would happen down the line. Now, it's not just the costs and benefits we have to worry about. There are real accountability concerns that people have about coordination among agencies. And I'll just list you the sort of top of objections people might make. One is shirking. What people say is fragmentation and dispersion of authority across agencies creates an extra risk, a worse risk that agencies will shirk their duties. There's always a risk that an agency will drift from what Congress told it to do. But if there's more than one agency, they can point at each other and go, your job. And so maybe fragmentation makes the risk of shirking worse. And I think that's entirely plausible. I think coordination is a response to that problem. That is, I think that coordination puts the agencies in the position of holding each other to account. It's as if they're monitoring each other for the Congress, so they can serve a monitoring function and help reduce shirking and drift. The other problem is that one agency might dominate the other. You might think of agencies as bullies. Maybe they'll get together, and one of them is more powerful than the other. They have more resources, they have a better reputation, they're known for better expertise, they have more support in members of Congress, they have more support from the president, and they just steamroll over the other agency. So there might be winners and losers. That can happen. But of course, in a fragmented situation, that happens too. So it's not clear to me that that's an argument against coordination. And in fact, coordination might help the weaker agency occasionally piggyback on the stronger agency to get something done that it otherwise couldn't do. But then there's the risk of collusion. Maybe the agencies will get together and strategize about how to undermine congressional mandates. That is, they'll get around things that Congress doesn't want them to do. So imagine if Congress cuts off the funding of, I don't know, EPA and says, we're not really happy with this agency regulating greenhouse gases because we don't want to deal with climate change in this way, so we're going to cut off all their funding and they can't do any of that. Imagine if the agencies coordinated to pool resources with another agency to get around the appropriations ban. Well, the first thing is that would be clearly illegal. And so there would be an opportunity for judicial review of that kind of maneuver. And apart from this kind of brazen effort at collusion, it's hard to see, although I'm open to suggestion, it's hard to see the coordination really offers opportunities for a kind of undermining of Congress that wouldn't be caught by some other oversight mechanism. Another risk, bad compromises. Agencies will get together and they will try to achieve consensus because they'll get tired and because their principals will tell them, get to agreement. And so Agency A wants a more stringent health standard, and its cost-benefit analysis says it's well worth it. Agency B wants a less stringent standard, and its cost-benefit analysis shows it that the marginal benefit of the additional increment of safety protection isn't worth it. And so they pick a place in between that is actually supported by the range presented by the data. So there's nothing, the data supports it, but the data is not driving the actual decision. What's driving the decision is they agree. Now what's wrong? So what's wrong with this? Is this a bad compromise? From the perspective of some interest group, one interest group or another it might be, but from the perspective of whether it's lawful, it seems perfectly lawful. If the statutes allow each agency the discretion, if the statutes don't dictate this outcome or don't preclude it in some way, then it seems as long as the record can support the outcome, and it's not an outcome based purely on raw politics, it seems perfectly lawful and defensible, and I'm in favor of those kinds of compromises. Finally, the worry about the president overreaching, the president exerting too much centralized supervisory control in an effort to coordinate, to advance his policy objectives. Now, how you feel about this depends on how you feel about the unitary executive theory. There are scholars who argue that the president's ability to direct outcomes of administrative agencies is limited, that unless Congress specifically delegates the decision-making power to the president named as the president, then the agencies possess the power and the president can't tell them what their outcome should be. And there are other scholars who argue, including former dean and now Supreme Court Justice Elena Kagan, that the president enjoys a broad discretion and flexibility to dictate outcomes unless it's specifically precluded by Congress. It is hard to go to work in the White House and come out without thinking that is totally right. You root for your guy, you root for your team. You can't imagine another team's going to come in and do, you can, but at the moment you think, we got this, we can do this. And so you have to moderate your hubris and try to be scholarly about this. So here's the scholarly argument for it instead of I just like my guy. The scholarly argument is that the president has a constitutional entitlement to advance his policy prerogatives through the instruments at his disposal. He is free to try to promote coordination, try to request and direct the agencies to deliver the outcomes that he wishes. They ignore the president at their peril. Obviously, senior level officials can be dismissed. They serve at the pleasure of the president. But they are not the weak little agencies that just follow directions that you might imagine. Agencies have a tremendous amount of tools at their disposal to resist centralized presidential control. They leak, they jam you, they do it anyway, they get Congress to back them up, they call their constituencies to lobby the White House. They have many mechanisms at their disposal, and the president is only one among the many constituencies that they answer to. Congress also, if it's unhappy, can intervene by passing a statute, by using its power of appropriations, by holding hearings, by holding up nominations, and by doing the variety of things that Congress is entitled to do. So I think that political interplay should be normally allowed to play out, and only at the outer boundaries should we worry about overreach. And the good news is there's somebody policing the outer boundaries, and that's the judiciary. So the courts have an important role to play, patrolling the boundaries of that interbranch struggle, ensuring agencies stay within legal bounds and don't coordinate their way to unlawful outcomes. And courts must do this without, in my view, erecting unnecessary barriers to coordination. Now, here's how that works. Courts currently don't provide any special standard of review to agencies that come in and say, we've agreed. 5 of us agree. There's no extra points for having come in with the agreement of a number of agencies. The same standard of review applies, typically the arbitrary or capricious standard of review. The agency has to demonstrate that it's making a rational decision, supported by analysis and evidence, and within its policy discretion. I know this because recently, in the Kerr, Alaska case, the Supreme Court decided a case in which both EPA and the Army Corps of Engineers share authority to implement the Clean Water Act. They had written a joint rule together. They had then interpreted that rule because it was ambiguous. And the court ultimately deferred to their interpretation of their own ambiguous rule, not because they agreed. In fact, although the court mentioned numerous times these agencies went through this process jointly and they agree and they're aligned, the court actually paid no attention to that when it went to applying the standard of deference to give. The court demanded the same justifications from the agency. So the deference that the court gave was based on the same things that would have applied had an agency independently interpreted this rule under the Clean Water Act. So review under the arbitrary or capricious standard should, on balance, all things being equal, result in more deference more often to collaboration or to coordination, not because the court is cutting the agencies a break, but because if I'm right, that coordination produces better decisions, that are better defended and better thought through and better supported and harmonized and have all the attraction of overcoming conflicts and inconsistencies, they ought to be defensible as not only rational, but terrific. And the court should defer to the terrific. It's the Freeman terrific standard. I think it's less relevant. The presence or absence of coordination is less relevant to the application of deference to legal interpretations by agencies. So now we get a little bit administrative law nerdy for just a moment. The test for whether an agency is entitled to the Chevron review for their legal interpretations of law is the Meade test, or known as Chevron Step 0. The inquiry here is, does Congress empower the agency to speak with the force of law, meaning that it should therefore be entitled to the deference we owe to agencies that are entitled to act to regulate with the force of law? That inquiry is about what Congress wanted to do. It has nothing to do with what the agencies are up to. So I think whether the agencies agree or don't agree doesn't have much to do with the inquiry into whether the agency is empowered to speak with the force of law. However, when courts have been unable to discern whether Congress has authorized the agency to speak with the force of law and therefore is entitled to Chevron review, it has looked for indicators. And in the past, it has said, if you use a particular format like notice and comment rulemaking, or other formats that conform to our expectation of high procedural regularity, we will infer that you were charged with regulating or speaking with the force of law and give you Chevron review. So, follow me, so if agencies engaged in coordination more often happen to decide to use those very procedural formats, like notice and comment rulemaking that binds them together in a joint regulatory process, it could entitle them to Chevron deference, Chevron review that they wouldn't otherwise have gotten had they chosen a different format. Likewise, if they elevate the matter to higher level officials who sign off on it, that's another criterion under the Meade test for whether, and subsequent case law, for whether the agency is entitled to get Chevron review. So coordination could indirectly affect whether the agency gets Chevron review, but not directly. When it comes to Chevron itself, the famous two-step test for whether an agency's legal interpretation gets deference, the first part of it, to the extent, and if Adrian Vermeule is here, I apologize, to the extent that Chevron has two steps, not one, the first step is, did Congress address the precise question at issue, the question that the agency is trying to answer? And if Congress did, you're done. That's the answer. Doesn't matter what the agency thinks. Again, that inquiry is about what Congress intended, whether Congress addressed it. It doesn't matter if you got 5 agencies agreeing, 9 agencies agreeing, 12 agencies agreeing. So I think Chevron Step 1 doesn't really affect, I think coordination doesn't really have much of an impact at Chevron Step 1. To the extent that Chevron has a Step 2, some people say it's just one step. If it has a Step 2, then the question of Step 2 is the agency's interpretation permissible? Now, there's one theory that says that question is the same as the arbitrary or capricious question. Is the agency's decision rational? If that's the test for Chevron Step 2, agencies should get deference for their legal interpretations, more often on balance if they've used coordination to produce better decisions, just like they would under the arbitrary or capricious standard. And if Chevron Step 2 is different, because some scholars think it's not that at all, it's actually just a kind of repeat of Chevron Step 1, is the agency's interpretation permissible? Well, then coordination's irrelevant again, because it was irrelevant at Step 1, and that approach just conflates Step 1 and Step 2, so it's just Step 1. I feel like I've worked that out. Now, courts could go further. What I'm arguing is, if courts just do what they do and apply the existing standards of review that we all know from administrative law, my claim is that if coordination has the benefits that I purport that it has, more often the agencies will get deference. And if they blow it and they overreach and they together interpret a statute to give them authority that Congress clearly doesn't give them, the court will perform its role and tell them that they're wrong, whether there's 1 of them or 4 of them or 12 of them. And that this is all good. This is all to the good. But I think it's important the courts not step further beyond that and try actively to discourage coordination, just as they, I think, have no obligation to give a break to the agencies for having coordinated. It's important not to erect artificial barriers to coordination. And there are a number of cases that suggest that perhaps courts might be anti-coordination kind of subtly. And I want to mention just a few of them and then I will close. There are a few key cases that tell us something about how courts think about coordination. The first is Massachusetts versus EPA, where the court said EPA has authority to regulate cars and truck emissions under the Clean Air Act, even though NHTSA has the authority to set fuel efficiency standards. They can live together, said the court. And by the way, and this is explicitly in the decision, the fact that more than one agency has authority is no excuse for shirking, said the court. So that's a plus, that's on my plus ledger for pro-coordination. I like that language. Then, if you think about Gonzalez versus Oregon, a case in which the Attorney General interpreted the Controlled Substances Act to criminalize physician-assisted suicide, which threw a wrench into the states trying to legalize it. The decision turned largely on federalism principles. It's not a case about coordination. But one of the reasons the court in Gonzalez did not give the Attorney General deference, it said, so Justice Kennedy said, was that the Attorney General had failed to consult with Health and Human Services, the expert agency that had some authority, had the main authority to implement the Controlled Substances Act. And so even if it wasn't a main driver for the decision, the hint in the case is there's a related agency with statutory authority, with related expertise, you have an obligation to consult, or at least if you, not that you have an obligation, but if you don't, you run the risk that it will be another nail in the coffin of you getting deference. Then there's a case called Martin versus Oshirk, in which one agency, the Occupational Safety and Health Administration, had the power to set workplace health and safety standards. And another separate agency, more like a judge-like body, right, an adjudicative body, had the power to enforce those standards through hearings, to hear complaints about those standards, totally separate functions. And the court was faced with these two agencies implementing the same law, one the regulator, one the adjudicator, interpreting the statute differently. And the court chose the regulator. They said OSHA, the agency with regulatory authority, is the only one of the two that has interpretive power. And people look at the decision and say, you know, court's anti-coordination. Look, they're using doctrine to suggest that only one agency possesses interpretive authority. And what if you think more than one agency might possess interpretive authority? I think the best way to read Martin is not as an anti-coordination decision, but as a decision about what happens when two agencies don't agree, and they're interpreting the same statute, and the court has to choose one. If the court has to choose one, then the court has to choose one. But that says nothing, I don't think, about what happens when the agencies come and say, we agree. Right? So we don't know what the court will do if they say we'll agree. And finally, PCBG, the pension benefit, well, my acronym, ERISA, they implemented ERISA, who knows, Pension Guaranteed Corporate. Ann Carlson, I was not the founder of the environmental program at UCLA. I was the co-founder of the environmental program at UCLA, and the co-founder is sitting right there and just told me what PCBG stood for. This is a case in which the agency, which had the authority to implement ERISA, the Employment Retirement Insurance Security Act, like for 3/4 of you, I could say anything. This agency is responsible, once a company comes out of bankruptcy, the agency is instructing the company coming out of bankruptcy to renew its pension obligations. And the company is fighting it tooth and nail, and the company says, but you didn't think about labor law, and you didn't think about bankruptcy law, and you didn't think about all this other stuff. You didn't consider the interests of other policies embodied in other federal statutes when you told us that we have to renew our pension obligations. And the Supreme Court said they don't have to look at every policy embodied in every federal agency, especially that they have no expertise over. They're in charge of employment, retirement, security, and they have the authority to order you to renew your pension obligations. So you look at this case and say, oh, the court says there's no obligation for an agency to even consider these other imperatives that related agencies might be engaged in. But again, I don't think that's the right way to read the case. I think the way to read the case is, in an informal adjudication, when somebody's throwing everything in the kitchen sink at an agency to try to knock down its decision, there's no unlimited obligation to consult every other imaginable agency on every other federal policy embodied in every other federal statute. But it might be quite different if the regulatory regime actually identified other agencies that did have related authority and at least provided some kind of textual anchor in the law for some kind of obligation that a court might be able to link to the statutory text to say you do have some duty to at least consult or consider. So I don't think PCBG actually rules out the obligation to consult and consider, but I don't think it was raised by the facts of that case. There is some limit, though. Vermont Yankee, the famous case that says that courts cannot impose additional procedural requirements beyond what the statutory text requires. I think that precludes courts from inventing out of whole cloth a sudden obligation to coordinate. I'm disappointed, but I actually think that's true. So what do we conclude from all this? Courts will play their usual role policing agency boundaries and policing the interbranch struggle between the president, the Congress, and the agencies, and preventing overreach. This will help to reduce monitoring costs for Congress when Congress is worried about shirking and collusion and drift. And if the agencies want deference, then they might want to choose procedural coordination formats that are more formalized, such as notice and comment rulemaking, for example, like the joint rulemaking example we talked about. Now, it's possible after this, I don't think it's possible after this talk to think this, but one might. Think that these principles, the Congress, the President, and the agencies, have produced the optimal level of coordination already, because they have used these instruments to some extent. They presumably know what they're doing. So you could argue that they've settled on the right costs and benefits, and this is what we get. But I doubt it. Given the complexity of the fragmentation that I described at the outset, the extent to which power is dispersed, the endemic nature of this problem, and given the searing criticism in every domain, financial regulation, border security, food safety, natural resource management, that I reported to you, and there are many other domains we could talk about, I think it's impossible to believe this is the optimal level of coordination unless your goal is government inefficiency and ineffectiveness. So this is the recent installment in a larger intellectual project that Martha alluded to, described a bit, which is really an inquiry into the nature of governance. And I started to think about public-private relationships, how public agencies and private sector actors work together, how they might work together more. I tried to conceive of regulation more as a contractual exercise, more negotiated, more interdependent, less hierarchical, less dictatorial, and so thought about how regulation works as a contractual device. And most of this is just about a total fascination with institutional complexity and institutional design. I find nothing more exhilarating than to wade into the mess of those acronyms and look around and see who's doing what and try to figure out why they're doing it, and then to think about how the institutional players benefit in this separation of powers regime. The Congress, the President, the agencies, and the role that courts play. But in this conception, I must admit, courts do not play the main driving role. They're policing the boundaries. And administrative law, of course, puts courts at the center, traditionally. And it's not a surprise we therefore see lone agencies acting independently throughout the administrative law casebook and throughout the administrative law literature. But when I look at the agency in the casebook, I see an agency embedded in a web of interagency relationships connected to multiple principles in an institutional dynamic in which everybody's trying to get some advantage. And I want to teach administrative law that way and environmental law that way, because I think that's intellectually very rich and very, very challenging. In a cynical time, and even in a not so cynical time, it is the project of some to persuade that government does not work, or more perniciously, that it cannot work. I am against that project. I see my work in significant measure as devoted to making government penetrable, understandable to my students and to myself, and maybe to my colleagues some of the time too. And I see my work in significant measure as making the problems of governance compelling, so compelling that people will think harder and in more interesting ways and work harder and fight harder to improve it. Archie Cox was a truly great public servant with an emphasis on the word public. He believed in the public sphere and in public law values of transparency, fairness, effectiveness, and accountability. In a lecture he gave at the University of West Virginia in 1991 entitled Ethics in Government, Archie said that he worried about the, quote, decline of the public philosophy that shaped American ideals and long influenced American political life, and saw a need to restore faith in public service, to infuse dignity, respect, and impartial concern for the general public interest into the conduct of government. That project I am for. There is no better place to think about these issues than Harvard Law School. I am privileged to be here, grateful for my colleagues, indebted to my dean, and thankful to all of you who mean so much to me for being here today.